subject in the bilingual language. So class, we are doing the summary of the act and the exam oriented questions, right? So today we are going to do the LLP Act and Company Act. So first of all, let's understand the LLP. LLP is basically, it is the combination of Company plus Partnership Act. Okay, LLP is the combination of company and the provision of some partnership act. So now see what is written here in the paragraph. LLP is a body corporate with perpetual succession, existence of separate from the partners of the firm. That is called LLP, right? Any individual, it means these are the qualities of company: the body corporate, perpetual succession, separate from the partners, etc. Any individual or body corporate may be partner in a LLP provided that they are competent to contract. They are competent to contract. So we can say individual can become the partner in LLP and body corporate can become the partner in LLP because they are competent to contract. That is plus 18, sound mind, not disqualified by law. Every LLP have at least 2 designated partners who are individual, not corporate body. Only individuals can become the designated partner. So in LLP, the minimum number is 2, maximum is unlimited, and 2 designated partner, minimum 2 designated partners should be made in the LLP. So this is the basic quality of LLP. Every designated partner of a LLP shall obtain designated partner identification number, just like the director, just like class the director, because in the company we have read that in the company also the director need a director identification number. So same thing will be applied to the designated partner identification. The designated partner is responsible for all the doing of act, matter, things that is required to be done by the LLP. The LLP is incorporated once it is registered with the registrar. It means in LLP also registration is compulsory, just like the company. Okay, so LLP is incorporated once it is registered with registrar and gives a certificate that LLP is incorporated by the name specified. On registration, LLP may by its name capable of suing and being sued. It means once it's get registered, we can file the case and LLP can also file the case. So this is the basic, the quality of LLP, guys. That is important. Okay. Next, these are the summary. The mutual rights and duties of partner of LLP and the mutual rights and duties of LLP. So this is of partners and this is LLP, and its partner is governed by the LLP agreement. So this is very important that in LLP, the one of the most important document is LLP agreement. So the right and duties of LLP and the right and duties of partners are written in the LLP agreement. Is that okay? Because we have read in the partnership. In the partnership, the important thing is partnership deed. In company, the important document is MOA and AOA. Right? MOA and AOA. Okay? And in this one, we can say here, partnership agreement is there. LLP agreement is there. The rules regarding different conversion are provided in chapter 10 of section 55 to 58 of LLP, which has been dealt with in this unit beside the rules pertaining to maintenance of account. It means class, just like the company, the LLP also have to maintain the account, other records, etc. So basically, if I say that it's contain the features of company. Okay, and ma'am and sir, if you are feeling any doubt, please ask the question. Okay, please ask the question. Now, question: the advantages of which form of business organization is incorporated in LLP? It means in the this one paid class we have done that partnership firm can convert into LLP. private company can be converted into company, and the unlisted public company can convert it into LLP. So just search in this option that where these words are written. Private company and public limited company, no. Sole proprietorship, we have not done. Partnership firm, we have done. Partnership firm and the private limited company, yes. C is the right answer because we have read this point. We have class read this point. Okay, next. True and false. LLP has perpetual succession just like company. Say yes or no. The answer is yes. Yes. Minimum number of designated partner is 5. Minimum. Minimum number of designated partner is 5. That is no. Minimum is 2. Under LLP Act, resident in India means person who has stayed in India for a period not less than 180 days during the immediate preceding year. 182. The answer is yes. An individual shall not become a designated partner in any LLP unless he has given his prior consent to such act. An individual shall not become a designated partner in LLP unless he has given his prior consent. The answer is yes, because the prior consent is required if any person is going to be designated partners. LLP may appoint a designated partner within 15 days of the vacancy arising for any reason. A LLP may appoint designated partners within 15 days of a vacancy arising for any reason. That is not the right answer. That is no. Okay, class? So these are the true and false, and every points we have already done. Every point we have already done in this session. Every point. Okay, it's over, class. So this is all about your LLP. This is, guys, all about your LLP. Now it's the time to study about the Company Act. It's the time to study about your Company Act. That is important. Okay, now see. First of all, the summary. Company is a artificial legal person which is created by law and can be dissolved by law alone. Right? It's an artificial legal person created by law, dissolved by the law alone. It is invisible, intangible, exists only in the eye of law. Yes, we know that. We know that the company have a distinct feature. A company can enter into contracts in its own name. Why? Because company have a separate legal existence. It can acquire, dispose property, can be fined under the provision of law for the violation of law. Exactly. Right? It is a distinct entity from the members forming it. Since a company is a distinct legal person, we know that it has a own signature, common seal with the name of company engraved in it. Consequently, it is also different from the partnership firm in the number of ways. Yes, we know that. We know that. Okay, so this is about your company. Now, class, we have read the various types of company, that is on the basis of incorporation, liability, on the basis of public interest, holding, subsidiary. So there are so many types of company that we have read. So many types of company, guys. Right? Now, the important document of company is Memorandum of Association and Article of Association. So these are the basic documents required by a company prior to its incorporation has registered with the registrar of company. Yes. What is MOA? MOA give the basic details of company, its objective and the most important document for a company. And what is AOA? That is the important document of company, consists of a set of rules and regulations, bylaws made by company for the internal management. So the basic work of the basic document, that's OA, talks about internal management, and MOA its objective of the company, and the basic detail is given in the memorandum of association. Is that okay? Both MOA and AOA normally filed with the registrar of company before registration of company. That is important. And once registered, the effect of registration is that MOA and AOA bind the company to absorb all the provision of memorandum and article. It means the company have to follow whatever the things that is written in memorandum and the article of association. That's it. Okay. Now, what is doctrine of ultravirus, constructive notice, and indoor management? Everything we have just read. So if we talk about the ultravirus, it's laid down company cannot carry on the object not permitted by its memorandum of association. It means company cannot go beyond the rules and regulations. What is constructive notice? Every outsider is assumed to have read the memorandum and article of association. Exactly. Suppose if we have given the documents, whether the outsider read or not, it's none of company business. If the company have given, it is a right of outsider to read all the things. Indoor management laid down that outsiders are not required to see the compliance of internal regulations of the company. It means if the company have changed anything, so it's a company duty to tell the outsider. So indoor management is basically protect the outsider. Protect the outsider, and constructive notice protect the company. That's it. Protect the company. Now about the member class. Member of a company has been defined in section 2 clause 25 of the Company Act. Any person competent to contract can become the member of a company. Exactly. There are various modes by which company can acquire membership of the company. Yes, we have read. Every company is required by statute to keep updated register of members, debenture holders, etc. The register are to be kept in the registered office and open to inspection by the general public. And we have seen the rights of company. Statutory rights, that is given in the Company Act. Documentary rights, the right which is given in MO and AOA. And property rights, that is the journal rights. That is the journal rights. Now, about some prospectus. What is prospectus? The public company has to issue prospectus. That is the simply brochure before raising fund from the public. The company, the promoters, directors of a company have certain liabilities for any wrongful statement that may be included in the prospectus on the basis of public invest funds into the company by the way of subscribing to the share and the debenture of the company. And suppose if any misstatement is done in the prospectus, so the civil and criminal liability will be imposed. The civil and criminal liability will be imposed. The management of the company is with the board of directors. That's it. And the company can have maximum number of 15 directors. However, a company may appoint more than 15 directors after passing the special resolution. That is important. That is important. Okay. Every listed public company shall have at least 1/3 total number of director as a independent director. As a independent director. The central government may prescribe minimum number of independent director in the case of the class of public company. So who will decide? The central government. Independent director that's not work under the control of any other person. The methodology to be adopted for the appointment of directors, rules of retirement of director is with the unit. Other provision of Company Act as regard holding of qualification share by directors, maximum number of directorship that is of 20. Party transactions, loan to director, etc. Everything is written in the Company Act. Okay, now let's start with the questions. True and false. Directors are the actual owner of the company. That is true and false. Directors are the actual owner of the company. That is true and false. That is false statement. Company has to be compulsory registered under the Company Act 2013. That is true. Just give me a quick reply. Company cannot enter into contract in its own name. That is absolutely false because company have a separate legal entity. So the company can enter into contract with its own name. Yes. If all the member of the company die, then the company will be wound up. That is absolutely no. The company will go as it is. Company is a legal person with perpetual succession. Every question you have to do. Okay, now in the case of company limited by share, the creditor of the company can recover money from the member if the company is not making profit. Tell me, class. A company limited by share, the creditor of the company can recover money from the member of the company, can recover the money from the member if the company is not making profit. Why, Baba? This is absolutely false. Why? Because we know na company and the member have a separate legal existence. So with the fault of company, we cannot ask things from the member. Member cannot transfer share in a public company without consent of other. This is absolutely false. Why we need a consent? Guys, why we need a consent? No need to take the consent. We can easily transfer of share to the any person. Prospectus is generally issued by public limited company. Prospectus is issued by the public limited company. The answer is yes. Now, the minimum number of members in a private company. So the minimum number of members, minimum in a private company is 2. Minimum in public company is 7. Maximum in the private company is 200. Very simple questions are there. Maximum number in a public company is n number. The private company, minimum paid up capital, and public company, minimum paid up capital. What will be the answer? Tell me, class. This is important one. The answer will be no minimum requirement. No minimum requirement. In a government company, the government hold at least dash percentage of paid up capital. That is 51%. So I think from today's session, this is sufficient. And rest of all, 1, 2, 3, 4, 5. 5 things we will do it tomorrow. Okay? 5 slide we will do it tomorrow. Okay? So that's all for today's class. So if you are new in this session, do not forget to take this video courses in which everything is written in a very detailed form, right? In the video courses, you will get, okay, you will get the recorded class of ABM, BFM, ABFM, BRBL. Okay, and you can just see this is also a one kind of paid class, but in the recorded form. Okay, so this is of English and this is of English medium. You can also take the CAIIB Prime Test Pack, ABM, BFM, ABFM, BRBL. That's contain 2000 question. So this is very important. And this is your bilingual. This is English medium paid class. And this is your CAIIB ka Mahapack. CAIIB ka Mahapack, if you just take it for 3 months, it contain the content, it contain the mock paper, doubt session, okay, the marathon that we have done, everything is there in the CAIIB ka Mahapack. Okay, so this is very important from the examination point of view. Done, guys? So that's all for today's class. Have a nice day.